Whenever you are ready, yep.
So Furman versus Georgia is a Supreme Court case that was a huge victory for death penalty opponents, and it presented the question to the court of is carrying out a death penalty that violates the 8th and 14th Amendments constitutional. So on the night of August 11th, 1967, a man named William Joseph Mickey Jr. woke up in the middle of the night where he found William Henry Furman, this guy right here, robbing his house. Furman heard him coming in, so he tried to escape, and in doing so he ran over and tripped over some wires, and his weapon fired accidentally, killing the house owner. And he then fled, and he was later arrested, and claims he did not know he killed the victim until after he got caught. At the court, Furman claimed, "They got me charged with murder, and I admit going to these folks' home, and they did caught me in there. And I was coming home, backing up, and there was a wire down there on the floor. I was coming out backwards and fell back, and I didn't intend to kill nobody. I didn't know they was behind the door. The gun went off, and I didn't know anything about no murder until they arrested me, and when the gun went off, and I was down on the floor, and I got up and ran. That's all to it." And prior to that, the only thing the jury knew about him was that he was black and that he was not very intelligent. In fact, he went to the Georgia Central Hospital at Milledgeville for psychological examination, and they found that he tested in the lowest 4% of the test intelligence range, and he also dropped out of school in 6th grade. And therefore, it only took the jury an hour and 35 minutes to return a verdict of guilt and a sentence to death. And they sentenced him to death for murder because the shooting occurred during the commission of a felony. And during this time, there are two similar cases going on. There's a black man named Jackson, also in Georgia, and he committed robbery and rape. And there's also a black man in Texas named Branch who was convicted of rape, and both these men were sentenced to the death penalty. So because of all these cases going on, this got a lot of, the Furman case got a lot of publicity and attracted many lawyers, including Anthony G. Amsterdam, this guy right here. And he became Furman's lawyer, and they appealed his conviction and sentence. On May 3rd, the court delayed Furman's execution and said he could appeal to the U.S. Supreme Court. And the main argument Amsterdam used was that the death penalty was cruel and unusual punishment by violating the 8th and 14th Amendments. And Amsterdam went on to say that other studies showed that defendants who were black, uneducated, poor, or mentally ill received the death penalty more often than those who were white, educated, wealthy, and mentally healthy. And Amsterdam said that these random racial unfair results made the death penalty cruel and unusual. And the states, including Georgia, therefore must obey the 8th Amendment under the Due Process Clause of the 14th Amendment. So on June 29, 1972, the Supreme Court ruled that the death penalty is in fact considered cruel and unusual punishment with a 5-4 decision. And all 5 justices in the majority have different reasons as to why they oppose the death penalty, but Justice William O. Douglas has one of the more famous opinions, and he said that under English law, the death penalty was unfair if it was applied unevenly to minorities, outcasts, and unpopular groups. And then he reviewed many studies and realized that blacks, the poor, and the sick and uneducated received the death penalty more often, and he believed that the jury's decision was prejudiced by targeting these unpopular groups. So Furman, being both black and mentally ill and uneducated, makes him part of a few unpopular groups. And the most famous majority opinion is Justice Potter Stewart's, and his is really similar to Douglas's, and he said, "These death sentences are cruel and unusual punishment in the same way that being struck by lightning is cruel and unusual." And he then goes on further and explains that the 8th Amendment cannot tolerate the infliction of a sentence of death under legal systems that permit this unique penalty to be so blatantly and so frequently imposed. And then more other majority opinions include Justice Brennan and Marshall, who concluded that the death penalty was in itself cruel and unusual. They said it was incompatible with the evolving standards of decency of a contemporary society. And then also there's a lot of opinions of the minority side who were for the death penalty. and this included Justice Harry Blackmun, and he argued that capital punishment had always been regarded as appropriate under the Anglo-American legal tradition for senior crimes, and that the Constitution authorizes death penalty when it references taking life in the 14th Amendment. And the significance is that it did not abolish the death penalty, but it did place stringent requirements on death penalty statutes, and it upheld the notion that all citizens, regardless of race or group, are allowed a fair trial, and it deemed that death penalty procedures as cruel and unusual punishment.
All right, great job.